Hey, and pause. I'm not going to show you what I'm playing because that's the topic of today's video. We're going to be talking about software emulation, copyright, and some recent takedown requests, and what this is and why it got this stuff all involved in it. That's today on Weekly Dad News, right after we do this, which is our fair use statement. Anything that we're using in this is news and commentary, it's repurposing, it's reframing, we'll talk about all that stuff. Oh, my princess is in another castle. We are going to get a little wonky, but I hope to actually have some stuff in here, anecdotes and things to keep you engaged as well. So what is this and why do I have a piece of technology that I brought to a video thing? This is a Steam Deck. It's made by the company Valve. It is basically a PC, but it's geared around playing games and that's it. It runs on Linux, which is the third kind of redheaded stepchild in the operating system world. You've got Windows, PCs, and Windows, Mac, the Apple operating system, and then Linux distros. So this basically will run almost anything that you have in your Steam library. So games that you've bought 20 years ago, you can still, some of them you can play on here. Ones that don't, there's a fan group that comes in and like puts together so that you can run on here. But what has gotten this piece of equipment such renown lately is beyond its ability to play all the new games and you buy them on PC and then play them on here, is that it can do what's called emulate. And an emulator is a piece of software that pretends like it's an old system. So like an old Nintendo Entertainment System, an old Sega Genesis, old PlayStation 1. So emulators are there so that you can play your old titles without having to track down an old system or without having to worry whether or not your old system works. I don't know if all the kids that are watching will remember, but I certainly remember all the different ways I tried to make a Nintendo cartridge work. If you put it in and it didn't work, you'd blow on it, you'd put the eraser and scrape along the back. You'd also get Q-tips to clean off the contacts so it'd make. All that's gone with emulators. Once a group has programmed an emulator and put it out for an operating system, PC or Linux or whatever, then you can take the data off of the cartridges from your Nintendo or your discs in the case of PlayStation, and you can turn them into a little digital file instead of a piece of hardware and run them on stuff like this. So you can play old games. You have Super Mario Brothers, you can play Duck Hunt would be weird because you don't have a gun, but Super Mario Brothers, Super Contra, all of the old stuff you can play on here. The emulators get better and better as the power of these things goes up and up and up. So they've been able to make emulators for Switch games, and that's where today's story gets to. The company that makes an emulator for Switch, called Yuzu, that's the software, settled a court case that Nintendo brought against them, claiming that their software primarily is for piracy. Now, this copyright claim fell under the Digital Millennium Copyright Act, but to get there and to catch up all this stuff, we have to go way back to talk about what the hell copyright is and why we should care about it anyway. So copyright is one of the things that's in our Constitution. Like when we put together the Constitution, the founders thought it was important enough to say, hey, you know what? We need to make sure that this is in here based on prior law. So the actual bit in the Constitution, it is Article 1, Section 8. To promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their writings and discoveries. The idea here is if you write a book and have some good ideas, you write a song, you create a new wheel, you create a new carriage, you create a new kind of flintlock pistol, any of that stuff, the founders went, yeah, this is important. We want them to do that. And this is the bargain that they made. They would use the weight of the judicial system and the strength of criminal enforcement to support the ownership rights of those works that are then copyrighted or patented in the case of inventions. So that's what pushes copyright in. After that, there's several times where the code is written into law and changed and updated. But if we go even further back than that, the whole reason copyright exists is because in the 1600s, there was this thing called licensing of the press. And printers were given exclusive power to print enforced by the stationers company. So like the people that made paper and ink and the things to print with. Like basically after Gutenberg invented the printing press and everybody started making them, a fledgling industry sprung up to support them, and it became just this monumental industry as printing took off, especially with the Protestant Reformation and the changes in the geopolitical norms in Europe. We'll leave those alone for now and stick with copyright. So this power to print, it also had the power and duty to censor. They were required to keep things out of the public eye that the public shouldn't see according to standards of the place that they were printing in. And this was renewed over and over every 2 years. And so there started to be protests over censorship, over who was deciding what they could see or not see. And so it got stuck and it wasn't renewed. The publishing group got together and said, hey, we want to get past this impasse. We think that the copyright, the right to copy the material and make reproductions of it, should reside with the author, who can then license with a printing company the sole right to copy. And so they got that passed, and the very first real copyright law is the Statute of Anne in 1710. And the Statute of Anne prescribed a copyright term of 14 years with a provision for renewal for another 14 years, during which only the author and the printers to whom they chose to license their works could publish the author's creations. This solves problems of what I guess you'd call counterfeit. Yeah, you'd call it counterfeiting because it's counterfeiting. But it solves the problems of once you print something and it's out there, every single other press can take what you've written, copy it, and then copy it. And they could do it on cheap paper and outsell you. So all of a sudden the standard of care and the standard of quality of a printer is part of the decision matrix for the people that are putting together their written works and want them produced. Like this makes a ton of sense for solving a commercial problem and a plagiarism and copy or counterfeiting problem, right? So they put this together. That's the first one, is the Statute of Anne. In the US, we have that bit in the Constitution, and then in 1790, we put the Copyright Act in place. And the Copyright Act is how all of this stuff is codified. It outlines what can be copyrighted, what is copyrightable, how the enforcement works, and what fair use is, and also when it enters into the public domain. Because that's the ultimate goal of copyright, is to give the protections to the authors, but what we're buying with those protections is the right for us as a society to have that work. It's a trade. You know, we use the force of law, you give us your creativity. And it's supposed to be there so that people go, oh, I know if I make something cool, I can profit off it for a little while before everybody can enjoy it. The Copyright Act of 1790 sits there. And then there's this mismatch between the copyright laws in the US and in Europe and just kind of all over the world. Different copyright laws in different countries, different states. So because of that, you have the Berne Convention, and the Berne Convention says, let's all universally recognize and agree on copyright. This also solves the problem of if you publish in the US and you have a copyright in the US, which you had to register, like, hey, this is mine, here's the date. You'd have to go and do that in every country that you wanted a copyright in. So the Berne Agreement says, hey, if you've got a copyright in the US and it's registered, we're cool. Don't worry about it. The next one that happens, well, there's a couple of revisions and stuff. There's one in 1909, but the biggest one, and this is something I hadn't even thought about until I was researching this, but the biggest one is in 1976. So think about the span between 1909, when they do a little modifications to the Copyright Act, and 1976. The reason they're now doing a revision to the Copyright Act in 1976 is because of all the stuff that's been invented since 1909 to 1976. Think about it, AM and FM radio. You've got the motion picture. You've got sound recordings. You have film. You have movies. You have TV. In that 68 years, 67 years, all of these things come on and they go, okay, copyright deals with books. How do we make that work for all of this other and new media? So they do. They put the Copyright Act of 1976 and they set up the entire system of copyright for modern pieces of content. And they do this in kind of two ways they really focus on is they kind of outline all the different pieces and they talk about it being fixed in a medium as the point of copyright. So you no longer have to go register with the government and say this, I wrote this, here's a copy, give me my copyright. You now, once it's fixed in a medium, once I write it down and can prove at what date I wrote it down, I now have copyright protection. I have to enforce that copyright protection by pointing out when somebody's copying me, but I have it. It's mine. I got copyright. Cool. That stayed in place for a bit, and then, and in 76, they changed the rules. So it's no longer the 14 and then an extension of 14, or they changed it again in 1909, but now they're saying, okay, it's going to be the life of the author plus 50 years, or if it's created by a corporation as a work for hire, it's 75 years from publication or 100 years from creation, whichever is shorter. This is where we start to get into this piece where this law definitely influenced the path of super long copyrights, and those are pretty long. In 1998, some of the stuff from a couple of major corporations were starting to come in the public domain, and Sonny Bono, Cher's husband, was a congressman at the time. And he famously got what's called the Sonny Bono Copyright Act, or the Mickey Mouse Protection Act through, which changed it to life of the author plus 75 years, or for a corporate piece, 95 from date of publication, or 120 from creation, whichever is shorter. So now, that means the minimum copyright protection on some of this stuff is 95 years. And it could, life of the author plus 75 if you make something when you're 20 and live to 100. And then it's 75 years after that if you've held the copyright. That's a long time. That could be 150 years. That's quite a long time. And this all of a sudden brings up new issues with copyright, some that we're facing now and we still haven't figured out. So these changes and these shifts are what we're currently kind of working under. We have one more piece, the Digital Millennium Copyright Act. And that changed the enforcement mechanisms and what other things could be copyrighted. So code, like the stuff that runs computers and you write video games in, code has had an on-again, off-again kind of relationship with copyright. There's portions of code that people say that they've copyrighted or that they've patented and will come after people to try and say, no, I wrote line 10, go first. And so because of that fight, it's been a real kind of back and forth with the courts going, where does this happen? Where does software fall into this? And so now we've gotten to the point where it's said that software is a type of expression, and there are parts of it where if the way that you express the code, you can copyright. There are other mechanisms that you can patent. It's really strange. So Digital Millennium Copyright Act talks about enforcement acts, and one of those enforcement acts is about circumvention. And that's anything that you do to circumvent a protection that is put in place to protect copyright. With software, this is specifically talking about digital rights management. Digital rights management, or DRM, is another little program running or a thing that kind of identifies that this is a copied version and not an original version. And if you do anything to change that, that's now considered a violation of copyright and you can be sued for. So there's a variant on this that I think is very interesting, and that's where people like Taylor Swift is remastering all of her old albums. And she's doing that, and this is strange, because I think if this was code, it might be DR, I don't know. So Taylor Swift, when she recorded her old albums, the masters, the original recordings were owned by a company called Big Machine. They're the ones that it was a work for hire, right? So they paid Taylor Swift to record her songs. Taylor Swift still owned the music and lyrics. She wrote those, she owns the copyright. But those master recordings were owned by Big Machine. And then in 2019, a guy named Scooter Braun, who's most famous for discovering Justin Bieber, signing Ariana Grande. His company that he's working for buys Big Machine, and then they own Taylor Swift's master recordings. And there were conversations about letting Taylor Swift buy them. It's unclear whether any of them happened before Scooter bought them or if it was after and it was trying to reconcile. There are some NDAs around it, so it gets kind of funky. But because they hold the copyright to these master recordings, Taylor Swift said, cool, you know what I'm gonna do? Since I'm not making any money off of all my original recordings, I'm gonna remaster everything. And so this is a brilliant business move, she goes in and she just records new recordings. So she has new masters. Some of them sound remarkably similar, well, almost identical to the originals. But now when you go look for Taylor Swift albums, there's both the original album and the remaster. And those remasters are blowing up the charts. And so when people listen to the remaster, Taylor Swift makes more money than the inkling that she'd get if they listened to the original, where Scooter Braun and his company is gonna get most of the profits. So that's a really weird way. You could almost say that she's circumventing their copyright by re-recording and re-releasing the masters. I think it's brilliant, it makes a lot of sense. But that's where this stuff is complicated. That's where this stuff, you look at it and you go, well, why are there two? And the answer to why there are two is laws and capitalism. And so Taylor Swift makes this brilliant play and she pulls the copyright out in that direction. The pieces that allow something to be copyrighted, like that allow her to have the copyright on the new masters and have her the copyright on the original songs, but somebody else had the copyright on the masters, are laid out in the Copyright Acts. And it's gotta be original, it has to be fixed in a tangible media, so it's gotta be, like this is a tangible media, paper is a tangible media, a recording is a tangible media, even the digital bits and bytes of Taylor's digital remasters count as a tangible media, where her first masters are on, I'm assuming tapes, I don't actually know, but it's long ago enough, that's my assumption. Copyright gives you, copyright holder, exclusive rights and control. It's for a limited use, and then there are exceptions in there for what's called fair use or fair dealing. A lot of those revolve around First Amendment issues, so the press can use a lot of stuff without having to go and pay the copyright holder. There's an exemption for libraries. It's strange and it's been challenged a couple of times. But there are these things that we say, yes, we want these things to be in the copyright law. We want them in the code so that we know that there are ways you can use stuff that doesn't violate. Satire, commentary, all these things are totally legitimate. Because of that, whenever you have a new thing come out that threatens any of the copyright structure, nobody really knows what to do with it, you suddenly have a fight, usually. One of the big ones there was Betamax, and that was with Sony Corporation of America versus Universal City Studios Incorporated. So the VCR came out, and everybody freaked out in the TV industry because the main use for a VCR at that point, this is not home movies, this is just VCR for home use, was time shifting, was recording the 8 o'clock news and watching it at 10:30, because that's when you could. Or recording a TV show that's only on once a week and then watching it the next day when you actually can. Like that was the whole goal of the VCR, was time shifting all of these TV shows so you could watch them at a different time. The lawsuit was around how that would infringe on the rights of the copyright holders, who are the broadcasters, ABC, NBC, CBS at the time, and the owners of the programs that were being shown. And this could be production companies like Universal City Studios, it could be ABC itself, it could be Time Warner, everybody was geared up and looking at this and was super worried about it. And On the question of whether Sony, with its Betamax player, could be contributing to copyright infringement, and this is their key argument, right? They're not saying that Sony specifically is infringing copyright. For Sony to be infringing copyright, they would have to be supplying the Betamax recorder with a pre-recorded 8 o'clock news or a pre-recorded episode of, 76? So I Love Lucy, right? So if it came with that in the box and they hadn't gotten a copyright, Sony would be violating copyright. But the argument here is that Sony made a tool that just violates copyright. So the ruling came down, it bounced around the lower courts. Like it went up and down on appeal, and then it ends up in the Supreme Court. And the ruling was non-commercial home use was allowed by a 5-4. So it was close. But on the question of whether Sony could be described as contributing to copyright infringement, the court stated, the question is thus whether the Betamax is capable of commercially significant non-infringing uses. One potential use of the Betamax plainly satisfies this standard. However, it is understood, private non-commercial time shifting in the home. That time shifting merely enables a viewer to see such a work which he had been invited to witness in its entirety free of charge. The fact that the entire work is reproduced does not have its ordinary effect of militating against a finding of fair use. So they went, cool, you can do this. You can time shift stuff. And what was born out of that was the entire home rental industry. We used to have just a mom and pop corner store that had rental videos in the 80s. And then eventually you had Hollywood Video and Blockbuster, and you had these giant corporations. And the studios realized that there's another profit center. You have this window of release where it's in the movie theaters. You have this window of release when it's on HBO, Cinemax, any of the cable channels. Then you have this window of release where it's on TV occasionally as a Sunday movie, and eventually it gets to video. And video was a huge market, massive. It blew up. It changed the entire scenario for films. You could have direct-to-video movies that didn't play on TV. They didn't play in the movie theater. They just went straight to video. So they found a way to take advantage of that shift, right? In the 2010s-ish, there was this company called Aereo. And Aereo was trying to piggyback on this kind of a ruling. And what they did is they had internet-based TV for any station you wanted to watch. But the way that they did this is they had these giant arrays of individual antennas. And so if you wanted to watch a show, you got your own dedicated antenna. And Aereo's argument was, this is just like having a VCR and time shifting, except instead of you doing it at your house, we do it for you and then send it to you over a really long cord that is the internet. That didn't fly. They got sued. And unfortunately, while they won in the lower courts, the lower court said this is basically like previous cases that allowed for time shifting and allowed for it as long as it's a unique user to each piece. And then they lost at the Supreme Court. The Supreme Court said in a 6-3 decision that they acted as basically a cable provider. And now look at streaming. Look at what we just had with the Super Bowl, right? Now that is how things are. Sometimes it looks like these cases are brought so they don't have to buy the company. They don't have to invest in their own technology. They can hold the status quo a little bit longer until they can catch up. But at that point, they didn't want to catch up. It wasn't until just in this last probably 5-6 years that they've really switched over, and the streaming wars have been just burning up and burning through money. But that's because of copyright law, trying to figure out how to maintain control over their content while all these people are figuring it out on the side going, oh, look, what if we do this? What if we do this? And solving the problem for them. This kind of puts us into the space where we do need to talk about fair use. And that's because a lot of this stuff for fair use is one of the ways you'll see it the most. There was a recent case with Andy Warhol. And it's hilarious because Andy Warhol is like the definition of transformative use of the mundane. His stuff with the Campbell's soup cans, with Marilyn Monroe, with Prince, with all this stuff is iconic. You look at stuff and you go, that's probably an Andy Warhol, and if it's not, it's his style. So Andy Warhol did a cover for a magazine for Condé Nast Publishing, and the cover was a silkscreen print of Prince. Prince, the musician, he was a symbol for a while, phenomenal guitarist. The person who took the photo, his last name is Goldsmith, after Prince's death, saw what she recognized as an interpretation of her photo that was done by Andy Warhol that she'd never seen before. When she looked into it, she found out that when she had licensed this photo for a cover, a whole bunch of other variations had been made. And so she sued and said that they violated her copyright. Now there's a contract piece in there, but there's also this transformative question and goes, while there is a contract for her with Condé Nast, and then Condé Nast paid Warhol to produce this thing they used for the cover a long time ago, and now they're using a different one that they paid the estate to use, does Goldsmith have the copyright? And are they in violation of the copyright? And the Andy Warhol estate and Condé Nast said, well, this is transformative, it's fair use. And I think that there's still room to make that argument. And I think that that is transformative, but in this case, the Supreme Court said, no, it's not. It's not different. It's not, you're not recontextualizing it, you're just making a different kind of copy, right? A copy of the Gutenberg Bible where you can't quite read the lines is still a copy of the Gutenberg Bible. Now, is it transformative? Could that be fair use? It gets sticky, right? This is why we have the courts to adjudicate. And this is the kind of thing that we're doing in exchange for providing that stuff into the public domain at some point. Now, the public domain is not as rich as it could be because of the length of copyright, but that's the idea. I promise we will get back to this and the Yuzu lawsuit. Anybody that's here just for the Steam Deck stuff, we are getting back to it. This is just groundwork for that. Okay, so just recently, like in the last couple of days, New York Times, who bought Wordle, has been suing Wordle clones for copyright infringement. Now, the Wordle game where you guess a word, it tells you which letters are right and wrong, and you have 6 tries, isn't a new game format. It's a digitization of a cool idea, and they're suing for the implementation. They're suing saying the 5x6 grid and the color that letters turn if they're correct but in the wrong place, or wrong, is under their copyright. I bring this up because they've sent out hundreds of cease and desist to a Wordle, which is WIRDL, which is like apparently Shetland, I think. There's Reactl, which is a Wordle just entirely built on React that this guy wrote, and he's like, I just wrote it, you guys can all have it. So there's all these people making these clones. My favorite one is Birdle. Birdle is one in which you have to try and guess which bird it is in 6 tries or less. But all these are kind of fun, neat, interesting ways. They're done for different languages and dialects, so people that can't necessarily play Wordle can play these variations. That feels a lot to me like the New York Times reaching on copyright. But a lot of these guys have shut down because to go to court and challenge that, to go to court to chase that, is massively restrictive financially. It's very difficult to mount those court cases. That's why we have organizations like the EFF, the Electronic Frontier Foundation, that goes and can support these things. It's kind of like how we have the NAACP and a bunch of organizations that will support lawsuits for some kind of a rights issue and help go through that process. This Wordle thing with New York Times is similar to what's happening with the Steam Deck and what has happened to the Steam Deck related to copyrighted material. Okay, we're gonna get to it now. So, the emulators I was talking about, specifically the ones that run newer games that come on the Switch. So when you're talking about emulating like the Intellivision from the 1970s, early 1980s, Atari, ColecoVision, heck, there are emulators that will, well, I guess they're not really emulators, they're just little code bases, but that will play the old LCD screen games that just had like 2 or 3, it was like Casio watch games where you play on your watch. But because this has become so powerful, this Steam Deck that Valve made, a pretty good thing, and it can run all that stuff, there are people who own both a Switch and a Steam Deck. And when they travel, they don't want to carry both. They want the freedom to play Helldivers 2 or Pokemon Go. Well, Pokemon Go's on your phone, but big games. They want to play Civilization or XCOM. They want to play that, but then they also want to play Zelda games like Breath of the Wild or Tears of the Kingdom. And that's the sticker. But with Yuzu, which is named after a plant, you could do that. You load Yuzu on here and some other pieces of code, and then when you want to play your Breath of the Wild, you have to take your cartridge from your Switch, plug it into a special piece of hardware on a computer, download that, and then recompile it, and then you can port it over to here, but you've got to get your hardware code from the Switch and put it into Yuzu. So technically, that is 100% legal. This has been gone over in emulators. If you own the physical cartridge, you can do whatever you want with it. It's getting more complicated now that you don't own the physical cartridge. All of my Steam games, I've never owned a physical copy of. They're just ones and zeros that I paid Steam to hold on to for me, like a locker. Then I go into my locker and figure out what I want to play. Since Nintendo continues to use physical media and does not have an easy way to access historical games, like stuff from the Nintendo, the Super Nintendo, heck, anything that ran on the Virtual Boy, since they don't provide those, fans go and recreate them and create ways to play them again if they have the cartridge, and sometimes if they don't. And that's where this bumps into problems, because if you're running Yuzu on here so that you can play Breath of the Wild, but you don't want to go through all that thing of plugging in and recompiling and putting the thing and getting the codes and doing that, it's a lot easier to just get on the internet and type Breath of the Wild ROM or codes for my Switch and then put them in. And so that was the argument that Nintendo made, and they were right in part. They were right that there is piracy happening around Yuzu. But if we go back to the court case with the VCR, is there a legitimate use? Yes, there is a legitimate use. Does it outweigh the illegitimate use? I don't know how that plays out legally. Culturally, I think that the benefit of being able to play games that get abandoned by the developer or play games on a different system than the one you got it on is valid. There are people, so Switch has a smaller screen. You can plug it in and play it on your TV, but it's going to be a lower resolution. Emulators have allowed people to play Breath of the Wild and Tears of the Kingdom, the Zelda games, at 4K, 120 frames a second, so it looks just like butter. They've remade packages so that the textures upscale. The amount of work in the fan community is amazing. But once Nintendo decided to go after Yuzu, the challenge was to find somebody that was going to foot the bill for that lawsuit. And Yuzu did not find anybody to do that. They were making about $20,000, $30,000 a month off of Patreon to support their work. And then it was just kind of free. It's out there, it's open source. So Nintendo said, hey, cease and desist, you're violating our copyright, you're enabling piracy, you're violating the Digital Millennium Copyright Act circumvention piece. So Yuzu settled for $2.4 million, which will wipe them out. They gave everything to Nintendo, the domain, everything they have. If you go to yuzu-emu.org now, you get the hello users and Citra fans. We write today to inform you that Yuzu and Yuzu's support of Citra are being discontinued effective immediately. It goes on to say that they've been against piracy, but we now see that because our projects can circumvent Nintendo's technological protection measures and allow users to play games outside of authorized hardware, they have led to extensive piracy. Part of the thing that leads to piracy is lack of access to be able to play things the way you want to play them. What if, and this is crazy ask and it's never gonna happen, but what if Nintendo sold Breath of the Wild and Tears of the Kingdom on Steam? Then you could buy them and play them on here without doing all that rigmarole. But they don't want to. There's a lock-in. They want you to play on their software. Apple's doing a lot of the same stuff. So you get in this spot where corporations want to hold control and they're trying to do hardware lock-in. But what we're seeing now is that as computers get more and more powerful, something like this, I mean, look at how crazy these are. You can play a lot of great games on these too. They even have little things that clip on to play. But as computers get more and more powerful, we're looking at a time where you can probably play any game on any system. Xbox is talking about getting out of the console business. They're having serious discussions inside the company of going, okay, well, do we want to be a hardware company or do we just want to be the platform that these are played on? And to that end, Xbox Live and the Xbox service system streams games over the internet, so you don't even need good hardware. If you have a good internet connection, you can play games without downloading them. So all of this is going to come to a head and going to push us into this space where we've got to figure out how to deal with these copyright issues besides just yelling at each other and paying $2.4 million and having to write exactly what the corporations tell you to on your website. And this comes to more of a head, like all these images that I use that say AI generated under here, I'm doing with Midjourney. Midjourney, DALL-E, Stable Diffusion, and then even ChatGPT, all of these companies are now in danger of violating copyright, maybe, but we don't know. New York Times is suing ChatGPT right now for violation of copyright. ChatGPT is going to bat. It's going to go for it because it has the money to do so. As we look at how artists are treated and what happens with these AI images that are generated, how do we balance the benefit of progress and what's in the public domain with what's still under these antiquated copyright protections that hold stuff like Steamboat Willie out of the copyright for as long as it did? Now I can put him there and he can hang out as long as he wants. You just play it on loop and it's nobody's business but ours. But that change has to be discussed, it has to be addressed, and it has to be done with laws and acts and code. And I don't know if we're gonna have that happen in Congress anytime soon. They're too busy not passing funding legislation. But I do think we can figure out a way to benefit the rights of creators with the rights of capital and the rights of consumers. Because when we lock stuff off, when we lock parts of culture off from the experience of others, our culture becomes shallower. Don't know where to go from here, but the copyright stuff is a mess. I gotta go. My princess is in another castle. Oh, that might be copyrighted. Dang it.